All right. Welcome, everyone, to the University of West Los Angeles. I'm very excited today because we have a symposium on artificial intelligence. This, as many of you know, has been a technology that has been incredibly disruptive, transformative of our economy, of the world, and also our professions. So, here at the School of Business, where I serve as a professor, we are looking into these issues and how they impact jobs, how they impact industry, how they impact law and society. And I am so excited today to have our speaker, Brennan Kato, here, who is a co author with myself as well as Professor Beach, who teaches in the business and law school here, on a paper dealing with some of the issues that have come up with AI, and particularly as it pertains to how we as society are using these tools and how the law is dealing with the issues that have come up because of how we have normalized its use. So, without further ado, I have for you Mr. Kato, who's going to be speaking to all of us today and presenting the paper that we have on this topic. So, thank you all, and I will turn it over to Mr. Kato.
So, hello again, I'm Brennan Kato, and I'm one of the co-authors for the paper Artificial Intelligence and the Illusion of Privacy, Social Norms, Disclosure, and Legal Uncertainty. So to start it off, as a freshman, especially being in high school, artificial intelligence or AI has completely taken over. I mean, it has become woven into every aspect of everyday life for me. And whether it's my friends using AI to generate photos of themselves as cartoon characters, to my classmates uploading photos of themselves to AI to rate who's more attractive, to now people even using AI chatbots as therapists and putting details about their life they wouldn't even tell a real therapist. And to truly highlight the absurdity of AI usage, my teachers have now been forced to use artificial intelligence to check for the use of artificial intelligence in my classes. And this is not just happening at the high school level, because I've talked to elementary school teachers with children 7 years of age being caught using AI. And it sounds funny at first almost, but it shows the absolute chaos that we're in right now. And because it's a fact that artificial intelligence is being used everywhere, all the time. And people are using AI for everything while not understanding the legal implications. And we could even take a look at recent case law in United States versus Hepner, where a CEO under federal investigation turned to Claude, an AI platform, uploading notes from private talks with his attorney, and a completely understandable act to make sense of a high stakes, confusing legal situation. But recently, a federal judge ruled that by typing into an AI chatbot, he gave up both attorney-client privilege and work product protection. And his sentencing is scheduled for, I believe, is October 7th, 2026, where he now faces a sentence to up to 20 years in prison for each of the made fraud counts. And so, one thing is apparent is that the way people use AI and experience AI is highly contrasting from the way the law sees it. And we could even look at the history, we could look at our history, and the rise of social media created a similar disconnect between rapidly evolving social norms and the law's ability to fully grasp those changes, and is leaving a generation exposed to a variety of consequences that they neither anticipated nor intended to have in the first place. Like, as you see, as of right now, many people are being denied jobs because of things that they posted 10, 15 years ago. And that's a major problem because, again, they didn't understand the legal implications that come with that. And judges in several recent cases have concluded that the use of publicly available generative AI platforms can result in the loss of protection under both the attorney-client privilege and work product doctrine. And so the question after all of this is, has our doctrine of confidentiality kept pace with pe how people actually interact with technology in modern society? And to look at that, we must first look at a reasonable expectation of privacy. And a reasonable expectation of privacy is practically the core of privilege analysis, yet it has no fixed meaning, or in other words, courts decide it by case by case. And the hard part with that is that a single interaction with an AI tool doesn't fit well into any existing legal category. There are many arguments for different interpretations, such as a journal entry, a search query, or a conversation with a confidant. And the law has well developed rules for each of those separately, but has no clear guidance for something that is all three at once. And the terms of service only makes this problem worse. So, for example, in a study of user behavior when joining a social networking service, found that 74% of participants skipped the private policy entirely, and those who did click through spent an average of, I believe, 73 seconds on a document designed to take nearly a half an hour to read. And the terms explicitly state and permit the user or the platform to provider to collect, retain, and in some cases disclose user inputs to third parties. And users from all over the world agree without knowing what they're consenting to. And and these are not just CEOs like I mentioned before. Young people are adopting AI at an alarming rate. And according to studies, 63% of teenagers use AI weekly, and yet 40% rarely or never consider avoiding uploading personal data to these systems. And research on youth and AI shows that younger users often lack the critical skills to evaluate how their data is being used, even as they engage with generative AI tools with increased frequency. And so the law has long held that sharing information with a third party extinguishes any claim of confidentiality over that information. And applying that same third party doctrine to AI interactions produces a result that directly conflicts with how people actually experience and use these tools. And research confirms that users consistently disclose sensitive personal information to chatbots based on an intuitive sense of privacy and not on a careful assessment on the platform's data handling practices. And so people are not using AI chatbots as casual search engines or like social media. They're using them as confidence because 82% of the study participants rated their chatbot conversations as sensitive or highly sensitive, and a significant portion reported disclosing health conditions, financial details, or other personal matters that they would describe as information they would not like disclosed to a third party. And without the proper education, people will obviously speak their minds in conversations with AI chatbots, sharing sensitive thoughts and strategies without the fear of it being disclosed in court. And even a court has admitted that it may be entirely reasonable for a person to expect some privacy and confidentiality when interacting with AI tools. And generative AI has already become woven into the lives of daily life for millions of people. And a recent study showed that generative AI platforms receive almost 3 billion visits a month, with ChatGPT commanding around 2 billion visits and 500 million users. And according to a Pew Research Center in June 2025, about 50% of adults under the age of 50 report using artificial intelligence approximately once a day or more often. And people turn to AI to draft emails, summarize documents, brainstorm ideas, and increasingly to think through complex problems, now including legal ones. And the legal profession itself has not been immune. The share of workers with at least a bachelor's degree who use generative AI on the job rose from 20% in 2024 to 28% in 2025, and approximately 1 in 5 US workers now report using AI in their work. And for clients facing legal trouble, the temptation to use these widely available and normalized tools to make sense of a confusing legal situation is entirely understandable. Yet, as recent case law demonstrates, that this reasonable reflex can carry heavy legal consequences. And recently, there's been two opposing court decisions. So again, in United States versus Hepner, the court treated AI platform as a third party and stripped away every protection. And Bradley Hepner, the former CEO of Beneficent, was under federal investigation for securities and wire fraud with allegations of misappropriating approximately $150 million. After receiving a grand jury subpoena, he turned to Claude, an AI platform developed by Anthropic, to help organize his thoughts and prepare legal defense. The FBI seized these documents and found no protection under both the attorney-client privilege and work product doctrine. In the same week, a federal court treated the AI platform as a tool and protected the materials. And this is Warner versus Gilbarco. And the court considered a motion to compel the discovery of the litigants' ChatGPT assisted materials and held that the materials were protected by the work product doctrine. And the reasoning is that AI platforms are tools and not persons. Waiver of work product protection requires the disclosure to an adversary, not to a software, which is what they ruled. And the court stated that compelling discovery of AI-assisted drafts would essentially nullify work product protection across most documents prepared in the present day. Because, as I said before, AI is being used by millions of people across millions of professions. And Hepner treated the AI platforms as a third-party recipient. And so evaluating confidentiality by the reference to the platform's terms of service. And so this not only goes to show how the law is completely outdated, but also largely undecided on how to classify AI, which is simply just not acceptable considering the widespread use of AI, and especially when you could use it to put people in prison. And an example of that in recent case law is United States versus RenderNet. Shows that when you type into a chatbot, it can now be used to put you in prison. RenderNet was charged with setting the spark that caused the devastating 2025 Palisades fire in Los Angeles, based off of evidence found in ChatGPT communication records. The criminal complaint alleged that he queried the software, "Are you at fault if a fire is lit because of your cigarettes?" Using records like these, the government established probable cause that Mr. Rendernet had the requisite state of mind when he started the fire. And if these type of queries were made to a lawyer, they would be protected by attorney-client privilege and would be inadmissible at court. And law enforcement would not be permitted to have access to this communication. And the case is scheduled to go to court in the near future and is anticipated to provide hopefully more insight into laws regarding privileged information in relation to the use of generative AI. And all that goes to show is that we are in a desperate need of change. I mean, just going to class every day, I walk through the hallways next to people who tell AI chatbots their deeper secrets, who use chatbots as therapists, all without understanding the heavy legal implications that come with it. And they are acting on the same gut sense of privacy or reasonable expectation of privacy, like how the law is used to protect diaries and journals, because that's what they're using AI for. And the privilege ruling should not depend on whether a child or an uneducated civilian failed to read a 30-minute long terms of service document. And so there needs to be more education pertaining to AI literacy in not only schools, but workplaces too. And ultimately, the law needs to have clear rules and procedures, and it needs to happen now to protect millions of people.
Thank you so much for that, Brennan. And I feel like we're all lucky to have your perspective, particularly being part of the younger generation, being in high school and seeing where the newer generations are going with this technology. And I think that you offer also a unique perspective because not only are you a high school student and you see the behavior of your peers and others, but you are also a judicial law clerk in the administrative law system for workers' comp, where you see that there are people that are injured on the job that don't have representation, and the system is designed to be protective over those individuals, particularly, those that are unrepresented. And I think that what you were highlighting, incredibly interesting. You're seeing a generational shift where people are more and more accustomed to, instead of going to a third party professional like an attorney, like a therapist, they're opening their phones and they're asking these legal questions, these other sensitive questions directly into AI because that's become the norm for them. And yet we see that there are significant consequences in the legal system where there are no protections with any of those conversations, right? And so, from your perspective, Brennan, um, whose whose job is it to sort of fix this problem? Is it it seems like it's an education issue among the newer generation. Is it for the courts to solve? Is it for the government to solve? Is it for AI companies to warn the population, and particularly the vulnerable population, right? Younger users, as you had said, that you see your peers, much in the way that cigarette companies had to be forced to warn, the youth and to refrain from, targeting them, to issue, disclaimers and warnings. Whose responsibility do you see addressing this very pressing issue going forward?
Yeah, so I say it's 100% the government because this is a widespread problem across the entire United States, and AI companies need to be held accountable. And the only way that that is going to happen is through the government and through implementing policies and procedures that make sure that kids aren't being exploited for their information and becoming vulnerable eventually.
Absolutely. And it could just be that the government is really the only party here, in a sense, that has the authority to do something. Because if we rely on the AI companies to self-regulate, they kind of have a conflict of interest, because on the one hand, they want more users to use the technology, and they don't want those users to be cautious or hesitant to use it necessarily, because it would, go against adoption of the technology. And so, to your point, it really is on the expectation is on the government, maybe more particularly the legislature, right? To actually have legislation and regulation that will directly address this issue, to hold companies accountable, to protect the general public, right? Is that sort of, do you concur with that sense?
Yes, yeah.
Okay, great. So, Brennan, thank you so much for speaking today, for presenting this paper. I think it's incredibly timely for all of us, and a lot of the public is, as you mentioned, unaware. Even people in the legal and business professions are unaware of all the ramifications. I mean, these cases that you mentioned involve CEOs of very large companies that are doing things that kind of, in hindsight, seem very, just foolish, right? Because of the ramifications. So clearly, we're seeing that if CEOs can get it wrong, so can high school students, so can the younger generation. And so we are dealing with a pretty significant issue that needs to be addressed here. So thank you again, Brennan, for presenting this paper as part of the University of West Los Angeles Symposium on AI. And again, thank you, and we look forward to seeing more of your work and your research in the field. Thank you so much.
Thank you so much.